Yes, ma'am.
May it please my lordship, lordship, I beg to mention item 29 of the hearing list. Lordship, here, item 29. I have received an instruction that the petitioners, the respondents have been regularized.
Through a cabinet decision.
Not regularized, absorbed.
Absorbed, regularization, that is all the same. So let the matter come up on 3rd
Okay.
No,
of April, and in the meantime, interim be continued, Lordship.
my lord, in that case.
What is the purpose of continuing with the interim when actually the petitioner's service has been absorbed?
There is a point, Lordship.
What
There
is
is
that
a
point?
point.
What is that point? You please satisfy this court. What is that point?
Interim is there, but then in violation of the interim order, when they can regularize or absorb the
What is that interim? What is that interim?
interim is not to make any regularization,
Oh,
but it is there. So it is my prayer that Lordship may kindly list the matter on 3rd
okay.
and let the interim continue.
Okay.
In the meantime, I have to seek some instruction.
Mr. Enzo,
My lord,
what is that interim?
my lord, he's representing another council.
I'm for some of the respondents here.
Okay.
Earlier, on this petition was filed on 16th of December 2022. Thereafter, interim was extended on 3 occasions.
No, what is that interim? This court wants to
Not to
know.
regularize.
Not to regularize.
Yes, Lordship.
Okay, okay.
Interim was extended on 3 occasions. Thereafter, starting
we
from
differ.
20th of March 2023, interim was never extended. Interim was never extended. In fact, for the 16 listings or 15 listings, they have not extended the interim. For the 1 whole year, they have not extended the interim.
Let me check it out,
Okay,
Lordship.
Okay.
I have the
Okay.
Thereafter,
It's okay.
the respondents, they were observed in service on 18 December 2024.
Okay.
That doesn't give them the right.
Thereafter, on 21st of January matter came to be listed. On that day, when during the mentioning hour, the petitioner's counsel was not there. The order is very clear. Thereafter, after we left.
What is that order, 21st?
After we left the court after the mentioning hour, he came and he extended the interim order after 18 listings, after nearly a year.
Okay, there is something to be examined. Let us list it on third.
Yes,
My lord, in that case, on third, I'm not available. I'll be
Okay,
out of.
what is your convenient date?
I have some difficulty with family.
Okay,
I
so
propose on 16th.
16th of?
Yes.
no, Lordship, this matter, Lordship, 16 is too far.
If it is today, I'm prepared to argue. If not, on 16th of April, because before that, I'll be out of for family problem.
So I think you will have to accommodate.
If
You
it
will
is
have to
today,
accommodate.
if it is today, I have no problem. If it is not today, on 16th, my lord.
Yeah, because actually, that issue, that the interim order was not extended for a year.
More than a year.
That will be examined, but today we will extend because actually,
Of
as
course.
per the last order,
No,
Lordship,
that's it.
as per the last order, it has been extended.
Even on the last occasion also, my lord,
No.
during the mentioning hour, it was not extended. After we left, only he came and extended behind our back.
no,
Behind our back,
I was not there, Lordship, I was absent.
behind our back, they have extended.
No, it's not behind or front, but
But tenure was there. But tenure was.
It's not,
Lordship,
it's not behind.
there be extension or not, the matter is subjudiced before this honorable court, Lordship.
That we will examine, that we will
Yes.
examine, because actually like, what I learned is that they were absorbed when the interim order was not in existence.
That is the
So
factual.
that is that we will
That is the
examine.
factual. process.
Anyhow, let us have a date.
Just for academic. Now,
Lordship, whether it is extended or not, their very weight up initial order is being challenged before this honorable court. And if there be whether absorption or regularization, if their appointment order goes, the whole case collapses.
That
Another aspect of
we will examine on merit.
They are so much pressing the interim order.
We will examine on merit.
Yes, Lordship.
I think we will consider your case. Let us have a date.
yeah.
Let us have a date.
On
If it is
16th.
on third,
No, Lord,
if it is on third, it is not possible. He will not be there.
I will be there on third.
then on 7th, Lordship, that is Monday.
My lord, I have some difficulties.
This difficulty has been going on and dragging on and to for delaying tactics, and it has come up to this extent. Lordship,
lord-
will kindly see
My lord,
the learned council
Mr.
has taken.
Just wait, Mr. Ashipre,
my lord,
whether you will be there on seventh.
I know I'll not be here. I'll not be here. Because that's why I'm saying.
That was what
If it is-
he took for
No,
more than a
no,
month. Let's
my-
be factual.
My lord, since she is here, my friend is
In
here.
order to
we're-
make this a
We are ready
fact.
to argue today. If she is prepared, she is present, she is making submissions, so let her finish her argument. We'll argue. Then we can close the case today within 10 minutes. Because the fact remains that in the absence of interim order, cabinet took decision, absorption order, formal order was issued. Now, what is to be, where is the reason? What is the reason to extend the interim?
No,
Now, number one, number two.
or without interim.
Number two, if they really think that the absorption order is wrong, if the absorption is illegal, because when the interim, then they can come before this court with different.
That is another issue, Lordship. This is a new cause of action. This is a new cause of action. What I'm here on this point is that when their appointment order is very initial and they don't have
No,
qualification.
let us not.
It's unqualified.
If you are actually banking on that submission, then you will have to challenge the new course of action.
That is another.
So let us fix a date for you. Give a date.
That's why. No, today, Lordship, I haven't gone through whatever they have, so that's why.
Okay, let us fix it on
16.
16th. Okay. Okay,
Mazur.
let us fix it on 16th. Okay. On on the prayer of the learned counsel for the parties listed on 16/4/2025 for
Hearing.
hearing. Okay,
Lordship.
okay. Okay. Yes, ma'am.
Worship, I think to mention here, I think 20 and 21.
Uh,
I heard the worship like this after 2 weeks.
Why? 2021? What is the matter, ma'am?
Worship here, the participants praying for minimum scale.
Minimum scale of pay. Okay. On the prayer of MS so and so, H. Zilliam. MS H. Zilliam, Learned Counsel for the petitioner, listed after 2 weeks. Okay.
I think we got your worship.
Yes.
One interim order may be continued.
Okay. The interim order passed earlier shall continue till the next return. That is in the first hearing, okay? For motion, item number 1. Yes, Mr. Fuseko.
Next object. Here the petitioner is the landowner.
Okay,
There, the petitioner father donated a lot of land.
okay.
Where the present sub-center. Turning more sub-center, more has been set up. Lordship, on the
You agree by the appointment of the private respondent?
lordship.
What is that impugn approval order? Which page?
Approval is at page 27. Lordship.
27. Yes,
26,
yes.
Lord.
27.
Approval and the
27. Approval. Impugn
27.
approval. Just wait. Twenty-seven.
is there.
And is there any notification? Is there any notification
Lordship,
appointing the
there is a, the next page 28.
28?
Page 28, next to 7. There's the impugn order, appointment date is number 4.
Who is the respondent number 4?
Respondent 4 is the son of the previous this thing, the medical attendant.
Okay.
Then on his retirement, the respondent 4 has been appointed, and he's the son of the retired one Mr. Sri Ganihong.
Okay.
The petitioner is the landowner. The petitioner has, on the retirement of Mr. Dano Connect MPS, he has put up his application to be appointed for consideration of his appointment on land ownership histories. As per the one, dated 5 March 2028, Lordship and the respondents, they have forwarded the application of the petitioner.
Mr. Yes,
That is at page 24 and
Fuseko.
25.
the learned counsel for the petitioner. By filing this petition, the petitioner is impugning the letter dated 13/12/2024 issued by the Government of Nagaland, Health and Family Welfare Department, Nagaland, Kohima, conveying the approval for appointment of the respondent number 4 as MTS at Shinga Mokok Subcenter under the establishment of the Chief Medical Officer, Mon. And the consequent order dated 16/12/2024 issued by the Principal Director, Directorate of Health and Family Welfare, Nagaland, Kohima, appointing the respondent number 4 to the post. It is the case of the petitioner that the petitioner as the landowner is eligible for appointment to the post. However, without considering the appointment of the petitioner, the respondent number 5 has been appointed. The respondent number 5, who has no right to be appointed to the said post, has been appointed. Stop. Issue notice to the respondents, returnable after 4 weeks. The learned counsel for the petitioner shall take steps for service of notice upon the respondents by registered post with AD, by registered post with No. Issue notice to the respondents returnable after 4 weeks. Madam, you are appearing? MS Pichano, the learned government advocate, appears for the state respondent number 1, 2, and 3. Therefore, no formal notice need be issued. Stop. The learned counsel for the petitioner shall, however, take steps for service of notice upon the said respondents by registered post with AD within a period of
3 days, Lord.
insofar as the respondent number 4 is concerned. Learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of 3 days from today.
What's up the interim period? The one was made in December 16, Lord.
It is made clear that the appointment of the respondent number 4 shall be subject to the outcome of this writ petition.
Last one.
For motion, item number 2. Yes, Mr. CT, what is your case?
Lordship has extensively dealt with this issue. And after.
Every issue is a new issue.
Yes, I would accept that. The matter has been crystallized by way of issuing an office memorandum by the government on 21st August 2017, which says that, which has clarified that a top contract appointment shall be counted if that is followed by regularization or regular appointment.
Correct.
Earlier, OM Lordship is well aware in the same post that has also been deleted and modified. But now, the latest office memorandum says that a top contract, work charge, substitute, whatever, followed by regularization or regular appointment, said post is deleted, shall be treated as public employment.
So it may be in different posts.
If it is, although it may be different, if it is continuous.
Correct.
And if there is any break or gap, the break shall not be counted for pension except resignation. Lordship may recall the issue in the Interim case. There, the resignation was involved. So resignation was treated as a resignation simply said because of the fact that in her representation, she has mentioned that to enable me to join in other posts. So that is connected. So, and Hintimo's case, Asala Ayer's case also, same issue was involved with regard to the resignation. So, except resignation, that means even if there is break or gap, when there is resignation, then another consideration will come. Here is a case where the issue of resignation is not there. That is why I admit what Lordship has said, that every case is a new case. Every issue is a new issue. That is what the issue is involved in this particular case.
Okay.
Petitioner has been appointed 3 times. Initial contract appointment, and by the order of the government, he was automatically terminated. And then after a gap of 45 days, he was appointed on contract while working as such. He was appointed on the basis of the recommendation of the NPC. So, second contract appointment and subsequent regularization and regular appointment is connected. There is continuity.
Okay.
That should be counted. That is my case.
So your case is that the service should be counted from the second
Second
appointment.
contract appointment, which is followed by regular appointment. But as for the OM, they are saying that since there is break and gap of 45 days, initial contract appointment should not be treated as a public employment. So that is my case. And this case has been, this office memorandum has been crystallized.
Are you, Mr. CT, are you still in service or?
Yeah, Still, I have.
Ah,
one more to-
if-
one-
if,
one more year
if,
to go.
that is
Now-
one more year to go.
Yes.
Okay.
Now, this office memorandum has been again discussed by this honorable court. 31st August 2017. In WPC 161 of 2023 and by an order dated 23/9/2024. This honorable court said that as per this office memorandum has been interpreted to the effect that when there is break or gap, that shall not be counted and that cannot be treated as a public employment as per the definition in the act. So far as the petitioner's case is concerned, it is already covered by that judgment. I will just cite the relevant portion of the judgment. Only 3 paragraphs. By going through all these 3 paragraphs, Lordship will also find the paragraph 26, 27, and 28. In paragraph 26, the previous litigations which were quoted in the rate appeals. Earlier rate appeals, series of rate appeals are regarding misimage case, which was arising out of RT Assan's case. And the WA 5 of 2017, Lordship was also there when Lordship was as the additional advocate general. Lordship was submitted in Sasikhala's case, WA 5 of 2017. So in all these cases, contract ad hoc substitute followed by regularization or regular appointment shall be treated as public employment and shall be counted for pension. Because the purpose is for, as per the definition of public employment, the appointment should be counted for pension. And appointment should be to any pensionable public service or post, which counts for pension. So the service has to be a pensionable
Okay,
service.
let us come to your case. Let us come to your case. Let us see your first appointment order.
Yes, court. Can we come to page 15? This is the type copy. 26,
Just wait.
February 1991. Computer document break 1 on contract basis. Page 15.
Yes, just wait. This is 26 February 1991.
Very good.
And thereafter,
First name is serial number 1 in the next page.
uh,
And then the second appointment.
yes, second appointment is,
Before that, Lordship, there is one extension order.
that's all right, that's all right. Second appointment,
Lordship, this extension order will be relevant because by this order, the petitioner's service has been automatically terminated. So the continuity has been broken here. That's why I'm referring to page 18.
okay,
This is also the
this,
right copy.
let us see,
This is the extension order,
page,
page 22, Lordship.
page 22, okay.
Extended for a period up to 30/11/1992.
Page 22, extension.
And then
The
Lordship.
contract appointment of the following. You are a junior engineer or officer or computer grade 1.
Subsequent appointment is officer grade 1, computer grade 1.
No, your continuation,
Continuation is
what is your serial?
serial number 11.
Serial number 11.
Yes. And
Uh,
second paragraph, Lordship.
SO grade 1,
Yes,
correct?
yes. And second paragraph, Lordship, you can see with starting with estate, Lordship. There are terms and periods of contract appointment is
the heck,
terminated
1/12.
1/12/1992 positively.
Just wait,
So-
this is extension and termination.
In view of this order,
Yes.
My service came to be terminated with effect from 1/12/1992.
Okay.
And then next, second contract appointment, my contention is my length of service should be counted from this. The pensionable service starts from here.
15 January 93.
Yes, page 26 is a type copy.
Okay. This is the second appointment order.
Yes. Fresh appointment note.
Yes.
This is also on contract.
Just wait, sir. You're appointed as junior engineer.
Yes.
You're appointed to the post of junior engineer
Yes.
or SO grade 1. SO grade 1. Just see your serial,
Yes, that's okay.
correct?
Yes.
On contract basis.
Serial number 11.
Just wait. This is fresh appointment
Yes,
on contract basis.
fresh appointment note on contract basis.
Okay. Thereafter,
Page 31.
page,
This is also that copy.
uh,
Page 31. This is under recommendation of the NPC.
you were appointed as sub-engineer.
So it is overseer grade 1.
Okay, your name, serial 8.
Serial 8 is.
On temporary basis. Okay, so your case is that your service should be counted from 15/1/1993.
Yes, second contract appointment, which is followed by a regular appointment,
What is the gap in service?
45 days.
45 days. Okay, where is the impugn order now?
Within order, there are 4 impugn orders. now.
Okay, where is that?
Page 35. This is only a letter, but then on the last occasion when the petition was moved. Because earlier it was more content withdrawn due to some technical difficulty.
Okay,
So my learned friend who is representing the government was making a submission that we have not challenged this. Court was convinced that yes, you should have challenged this later.
okay,
So I have challenged this now. This is just a letter and on the left hand side in the bottom, what you will find, copy 2, it is served to me also. This is letter by the government to the chief engineer. Forwarding the finding of the clean air department,
where is the finding? This is UO.
page 37,
This is only UO,
yes,
no finality.
Lord Chief. This has been communicated to me. And next order will be only the retirement order.
Okay,
Lordship has been dealing with so many cases. Government will just on the basis of this, he will issue retirement order.
I don't find the government's one reasonable. Okay, this is just UO number page, so the first will be page 36, followed by page 35 again.
Page 37 is. the-
No. Page 36. See, this page 35 refers to page 36.
Yes.
So this UO number UO 297. Page, okay. Page 36. UO 297 dated 15/6/24 and page 37 later.
Election age page 30 is
Yes.
the representation of the petitioner.
Just wait, sir.
I'm taking in the office morning.
Finding. Okay. Okay, this UO, in this UO, there is a finding that the initial entry into service of the petitioner is 26/20/1991.
Yes, that is
So,
the first.
so you are aggrieved by this?
Yes.
Okay, and then the second UO,
15,
where is the second UO page?
page 38, no. Second,
Second UO is
page 41.
page 41. This also same,
Yes,
the contents are more or less same.
yes.
Page 41. And page 40.
The first UO was communicated to me. I
Ah.
have again submitted the representation, but no, as per the Government Office Memorandum, 31st August 2017. Initial appointment should not be ignored because there is a break of 45 days.
Okay,
So I have submitted, you act in terms of your office memorandum. That is what I have submitted the resolution. It was forwarded by the chief engineer. And second, you also came in the same line. So
okay.
my submission is lordship. The engineer has issued the office memorandum and they are contradicting their own office memorandum. They are not following their own office memorandum. In my representation, I have clearly stated that kindly follow your office memorandum 31st August 2017. But they have again repeated the same observation also. That's how I agree with it.
Heard Mr. City Jamil, the Leonard Senior Counsel, assisted by Mr. Ayimchit, Leonard Counsel for the petition. The case of the petitioner, new para. In brief is that. What is this page 22? What is the date?
18 November 1992. In the next page, what you will find, page 23.
Ha. By the order dated 18/11/1992. The petitioner was appointed as
This is extension note. It's operate one.
no. You were appointed as by the order dated 26 February 1991.
Yes.
No, I think there is something wrong.
Initial.
Just wait.
26 to 1991 is the initial appointment.
26. Just wait. Yes, sir. Just wait, Mr. CP. Page 18 is your first appointment order,
Correct, Lord.
correct?
Yes.
So you were appointed as,
Uh,
there are two posts, computer/draftsman, grade 1.
the credit are same.
No, but you were appointed as,
Computer stroke draftsman grade 1.
is it?
Yes.
Two posts.
Both are used interchangeable.
Okay. Okay, ma'am. Case of the petition in brief is that by the office order dated 26 to 1991. The petitioner was appointed as computer/draftsman, grade 1, GR-1, within brackets civil, on contract basis for a period of 1 year. So thereafter, by the order dated 18/11/1992, correct?
Yes.
The service of the petitioner was extended up to 30/11/1992 with a rider that the contract appointment of the petitioner shall stand terminated with effect from 1/12/1992. Correct?
Yes.
So thereafter, by the order dated 15/1/1993, the petitioner was appointed afresh, correct?
Yes.
To the post of junior engineer, correct? Or to the post of, sorry, SOGR-1, grade 1, on contract basis. With effect from 11/1/1993, correct?
Yes.
And again thereafter,
That copy is at page 39.
and thereafter, the petitioner on successfully completing the selection process held by the Nagaland Public Service Commission and PSC, within bracket the NPSC, comma, the petitioner was by order dated 25/5/1993 appointed to the post of sub-engineer, within bracket overseer, close bracket, GR grade GR-1 civil, under the Nagaland PWD on temporary basis. It is the case of the petitioner that for computing 35 years of his service, it should be with effect from
15/1/1990.
with effect from 15/1/1993. That is the date of the fresh appointment to the post of junior engineer slash to the post of SO grade 1, and not from the date of initial appointment, that is 26/2/2022, 26/2/1991. Since there is a gap of 45 days in between the two appointments. Correct. The petitioner is however aggrieved, page 36. By the UN number, U stop O number 297 dated 15/6/2022 2024. In which the PNAR department has given a finding that the service of the petitioner shall be counted from the date of his initial appointment, that is 26/12/1991. And the letter dated 21/6/2024, by which the government has conveyed the finding of the PNR to the Engineer-in-Chief NPWD Nagaland Kohima, under which the petitioner is serving. Correct? The petitioner is further aggrieved by the UO number 1271 dated 4/2/2025, in which the PNAR department has again given a finding that the service of the petitioner shall be counted from the date of his initial appointment, that is 26/2/1991. And the letter and the consequential letter dated 10/2/2025, written by the Government of Nagaland Works and Housing Department to the Engineer-in-Chief NPWT Nagaland Kohima, conveying the findings of the PNR department. Stop. Issue notice to the respondents, returnable after 4 weeks. Mr. Kiangami, the then senior government advocate accepts notice on behalf of the state respondents. And
Yeah, Mr. Rashid, if I may, in this case, since the documents of the petitioner are still with the state government, the role of the accounting general is.
okay, we'll issue what was the last line, man? Therefore, no formal notice need be issued to the state respondents. Stop. The learned counsel for the petitioner shall however serve the requisite copies of the writ petition to the learned government advocate when in the course of the day. Insofar as the respondent number 5 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within a period of 2 days from today. In the interim, considering the submissions made by the learned senior counsel for the petitioner and the material available on record, this court is inclined to stay the UA number, U stop O number 297 dated 15/6/2024. Is there any annexure for this?
Yes.
Annexure?
Sure. 37.
annexure UO 297, I think you have not made any annexure. Right?
That copy is at page 37.
No. Your first UO is at page 36,
Yes,
correct?
yes,
Page 36.
yes.
Where is that the original?
Original is not available.
Not, so no annexures?
This is the annexure.
No, you have not given any annexure. 36? There's no annexure.
35 and 36. 36 is the enclosure in the page 35.
The, what was that, man? To stay the operation of the UN number 297 dated 15/6/2024, comma, the letter dated 21/6/2024. Correct,
Yes.
comma, the EO number 1271 dated 4/2/2025, and the letter dated 10/2/2025 till the next returnable date. Okay. For motion, item number 3. Yes, what is the case?
I was expected to vote this motion on behalf of Ms. Lang, Toxic Enemy, and 82 others who are the land owners.
What is the case about?
It is about land acquisition.
Okay, has it been acquired? No.
Yeah,
Has it been acquired?
they are saying, my lord, let me come to that. This land,
Has your land been acquired?
not yet acquired,
Ah,
illegally acquired, I should say.
no, I'm not speaking about legal or illegally, whether your land has been acquired or not, as of date.
It is not acquired.
It is not acquired, okay. Okay,
My lord, this petition is very simple, because there is no disputed fact in it, except the violations of law by the more, list of road and transport and highways.
we issue notice, let them come with notice. So the land has not been acquired as of date.
Not acquired.
Okay. Not acquired as per law, you forget that. Whether the land has been physically acquired.
No.
Okay,
Okay.
okay.
But construction is going on, building of road is going on.
In which para you have stated about the destruction of the properties? Let us see. Which para? Have you stated in any paragraph? Para 54. Limited effect. Para. No, there are so many petitioners. So the property which is sought to be dismantled as per your petition, have you given any particulars?
Yes, for 101 to 125 kilometers.
The particulars, the building, standing structures, the house, where have you stated that in your paragraph? You are saying that actually your property has been dismantled or proposed to be dismantled.
Proposed to dismantle.
That's why, where is your property? Where have you stated about those properties, the particulars of those properties, which is sought to be dismantled?
They are not given us any survey.
It is your case. You should identify the properties which is sought to be dismantled.
Not a single property, standing structure has been
So there is no standing structure.
Some structure is there, they have not
Then
done.
where have you stated in your petition?
I stated that only,
Where?
here in paragraph 54.
No, para 54 does not speak about that. Read your para 54. Read para 54. Read.
Despite repeated requests from the petitioner to expedite the process, the respondent has failed to take any action. The forceful commencement of road construction is set immediate to the attention of this honorable court. We ensure timely payment of the compensation and interest with the one.
That's,
issued to the executive board.
Huh?
We have a land stretching from 101 to 125 kilometers.
This court wants to know whether you have stated the particulars. You are stating, you have stated that your properties is sought to be dismantled, the structure is sought to be dismantled. So what house, what properties, what standing structure is sought to be dismantled?
That's right, Your Honor. But then, when they have not provided us any specification, any survey,
You are supposed to know your property, not the other side.
that too we know.
Where have you stated?
It's very difficult to mention from one. to
Sorry.
one.
Mr. So and so. Learned counsel for the petitioner. By filing this petition, the petitioner is challenging the proposed acquisition of the land for widening of the National Highway number 2 from Doyang 105 km to 125 km, Ijato village. It is the case of the petitioner that the proposed acquisition is sought to be initiated without following any established procedure of law. Stop. Issue notice to the respondents, returnable after 4 weeks. Mr. Imsum,
3, 4, 5, and 6.
Mr. Im Timsum, the learned additional Advocate General Nagaland accepts notice on behalf of respondent number 3, 4, 5, 6, and 7. Therefore, no formal notice need be issued to the state respondents. The learned counsel for the petitioner shall however take steps for service of notice upon the state respondent shall however take steps for serving the requisite copies of the petition to the learned additional AG Nagaland within a period of 7 days from today. Insofar as the respondent number 1 and 2 are concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents by a registered post with AD within a period of 7 days from today. Okay. Yes. From the supplementary costings for motion, item number 24. Yes, ma'am. What is it?
Where the petitioner, in the present application, the petitioner is praying for improvement of all Janaki village.
The other side, any objection? MS Spencer. Learned counsel for the applicant. The present application has been filed for impleading the Old Jaluki Village Council represented by its chairman, P.O. Jaluki -797110, parent Nagaland, as the pro forma respondent number 8 in the writ petition number 41/2024. 2023. Stop. The application for impleadment is allowed. We will order that in the main writ petition. In view of the order passed in ISC number 28/2025, the petitioner shall file amended course title and take steps for service of notice upon the newly impleaded respondent within a period of 7 days from today. Listed after 3 weeks. Okay,
Then to, self notice to distribute it to respondent number 8.
that is what we have, that is what we have ordered. Nothing more, nothing less. For motion, item number 25. Same thing.
This motion,
Ah,
motion for this, interpretive application was, completely filed before the motion.
ah,
In connection with the adjustment of the order dated, 26/9/2024, when the WC 318/2023, relating to the Bangladesh police. So here, the judgment and the order dated 26/9/2024 is very clear. The honorable court has given the observation and correction clause on the same. So we are under the condition, under the direction of the honorable court, we are following the, use all those correction. We are trying our best to comply the direction of the honorable court to initiate and recruit those police. So, Lordship, since there is a big will, we require some more time. So from which we have filed.
what is the, let us see the operative portion of the order, the judgment. Which page?
Annexure 1,
Page?
Annexure 1, that is IA 30. Annexure
IA
1,
30.
Yes,
Yes, I'm on that.
Annexure 1,
Page.
page 50, running page, starting from 56. Judgment and order, paragraph number 15.
Operative portion,
Operative portion is start from, clause 1. Page, running page 56. Annexure 1,
para 15,
yeah.
para 15.
Lordship, we are-
Just wait, just wait. Clause 3, 4. Clause 3, 4.
Yes. 7 and 8, there is a relief given by the honorable court and clause 7 and 8 also. So,
Where is 7 and 8? No, we are not touching this. We are not touching 7 and 8.
no,
We are touching 7 and 8. If it is for extension of time, we will confine ourselves only to that.
yes, so as per the direction of the honorable court, we are trying to complete, to initiate and recruit the.
That's why I,
Yes.
Mr. Imti, your clause 3. The time given to complete the process, clause 3, 4.
Yes,
The process of selection shall be completed
6 months.
at the earliest and preferably within 6 months from the
Yes.
date of the present order.
so in this case, 6 months will be expired by the next week. So your worship, as said earlier, we have already initiated and to complete the recruitment process, we are not in a position because of the willingness matter. So we approach the honorable court, pray for another extension of time.
Okay.
So as to complete the.
Where is the ground stated by you? Where is the ground stated by you in your application?
Your worship,
Let us-
my application,
Yes.
paragraph number 7 and 8 only. Part, especially paragraph number 8.
Para number,
So,
you refer the page.
paragraph number 4.
No, you refer the page,
Page number 24. Page 24.
page 24. There is no para.
My application, page number 24 and paragraph 4.
Page 25. Page 25.
And paragraph is 4.
Page 25. Yes, madam,
Lordship,
if the government is taking steps, why don't
Lordship,
you also, I think,
Lordship, I would like to submit my law.
yes, submit only on the time factor.
No, I'm not going to submit, just in the constable case, the bulky one, this court is all the same. This is what they are saying, that it is further respectfully submitted that the department has been taking steps in earnest to comply with the direction of this honorable board, but considering the ponderous administrative process involved, it is unable to meet the line of 6 months set by the honorable board, which shall expire on the end of March 2025, and faced with the impending prospect of contempt proceeding unless the honorable court is pleased to grant further extension of time in the interest of justice. Now, Lordship, I want to file my objection, and so I pray that the matter may be give me 10 days to file my affidavit in opposition.
In the meantime,
Matter,
the order passed by the court will expire.
Yes,
let that contempt proceeding, Lordship, that will depend upon the
No.
respondents.
No. It is actually like to recruit fresh appointments of more than 1,000 this person. The process is quite cumbersome, so we should also at least the government has taken a stand that it is trying its level best to see that the order passed by this court has been complied.
Lordship,
I'm passing some orders.
regarding the diploma of police, there are so many steps has to be taken.
Lordship, what process has been done by the respondent? At least let them bring a place before this honorable court, because Lordship, we kindly appreciate that 6 months or recruitment, whichever is earlier, now it has expired. Now, if it has expired, those respondents who are in service, both the repetitions, whether they have terminated the service. Lordship, because of this, they don't-
Madam, let us not be unreasonable. The 6 months time given for terminating the service of those person in service are still not expired. See, 6 months time has not expired.
One has expired yesterday.
So if it is expired, of course, then it is for the government to take action, but it has not expired. The 6 months period has not expired. And we don't know what the government is contemplating.
No, that's why, Lordship, I also have a right to submit, file my objection before this honorable court.
When time is given to you to file objection, the time will lapse. You file appeal against the order passed by this court. Okay, order in my chamber. We're allowing 4 months. Yes, if you are aggrieved, you file your appeal. Okay, next.
For motion item number 26.
This is same again. Item 26.
Send letter, send letter.
Okay.
For admission item numbers 4 and 5.
Yes, Mr. LT.
For the repetition.
File your affidavit.
Yes, ma'am.
Okay.
And on the last occasion, PTSD has paid for time to file a statement.
But your affidavit, let me see.
I never received it.
An affidavit by the petitioner about service. Okay.
For the repetition.
Affidavit.
24 September 2024.
No, Lordship, there is an order to file as per order dated 3/2/25.
I prayed for filing additional
Yes,
affidavit,
additional
if so advice,
Ah.
but till now, I don't receive the latest instructions. Therefore, may I pray that this may be listed for hearing, meantime, I may be allowed to file additional affidavit.
What about the CGSC?
Get the-
The CGST, even after giving last chance, they've been, time and again, they've been.
And what is your case, ma'am?
Getting compensation of damages.
For road construction?
Yes, yes.
So whether CGC is a necessary party? Necessary party. Mr. Fusako, you have for?
What's on the, appearing on behalf of Miss, Mrs. Yasundan.
Okay.
We will take. She has filed an affidavit.
Okay, Mr. Sanktam, you will be filing your additional affidavit. If so, advice means that the advice may never come.
My lord, in fact, in both the writ petitions, the petitioner is the same and we have been compensated. for damages caused.
Okay, that we will
Based on
consider.
that submission,
Every time this is for everyone.
court has directed
Okay.
you to file.
Okay, what about CGSC, correct?
Yes,
Yes, sir.
CGSC,
yes.
CGSC not yet filed, correct?
Yes.
Will it be necessary for respondent one?
It can be proceeded without CGC.
It can be proceeded.
Because his assessment and compensation was done by the state itself.
And whether the central government has deposited the amount, sanctioned the amount. Because actually the sanction has to come from the central government.
Yes.
So if no sanction is there from the central government, where will the state get the money to pay you?
This is the reason why the court has directed them to bring the information as per its court order.
Mr. LT, whether the central government has sanctioned the amount?
Whatever was reported, accordingly we have distributed to the landowners.
Under
Okay.
what provision they have compensated, that is what the court wanted to.
And you have actually like incorporated the sanction made by the central government in your affidavit in opposition?
Damage compensation,
Whatever you have paid, you have incorporated in your affidavit?
whatever amount was
Ah.
released,
Ah.
I have already stated in my.
In your affidavit. Okay, let's fix for hearing. Let us see whether you are claiming a double compensation or you are claiming a single compensation. Let's see.
In fact, my property is out of ROW.
ROW, yes. Okay. So even with or without your additional affidavit,
Yes, ma'am.
we take a chance for hearing.
Yes.
Okay. Yes. On the prayer of the learned counsel for the parties. Listed on,
7 if it can be. on
Seven.
front of the agreement.
okay,
Yes, ma'am.
7/4/2025. The additional AG, learned additional AG is also allowed to file the additional affidavit, if so advice, before the next date fixed. Okay.
For admission, item number 6.
Yes, ma'am.
We have to stay with the affidavit, so.
Okay.
Can that should be solved.
Next, Lordship.
Hmm,
Lordship, I'm also yet to file my reply, it has been filed by Respondent 5, Lordship.
okay,
So,
okay.
Lordship, you kindly convey this 2 weeks time, Lordship.
The
Last chance of people.
The learned government advocate is allowed 2 weeks' time to file the affidavit in opposition. So also, Mr. Fuseko, the learned counsel for the petitioner is allowed the same time to file affidavit in reply to the affidavit in opposition filed by the respondent number 5, listed accordingly. Okay.
Lordship, Interim, Lordship. Kindly read in continue.
The interim order passed earlier shall continue till the next returnable date. Okay.
For admission, item number 7 to 9.
Mr. Moa. Yes,
Yes, your lordship, I say.
you are smiling as if you are having a very good case.
Ever so, till I share. Oh, your lordship, from the last. Please, second time, but we are under discussion,
Ah,
department is under discussion. For the negotiation, so I need.
what is the case? What is the negotiation about?
This about the contract work,
Okay, okay.
which was executed.
But the petitioner has not filed affidavit in reply.
No,
You are the petitioner. You have not filed your affidavit in reply. That is what the office note shows.
no, your lordship,
Ah,
I filed the counter affidavit.
Now,
in the meantime, the petitioner saw what is for to have a negotiation between the contractor and the department, tourism department. It was accordingly allowed by this amendment.
Okay.
So now, tourism department have to take some step. So.
Any negotiation?
No membership so far.
Okay, we will give time to the petitioner to file affidavit in reply. In the meantime, if any negotiation is possible, carry on. But will not reflect that in the order. Okay. The learned counsel for the petitioner is allowed 3 weeks time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Okay, let's take a call. Okay.
For admission, item number 10.
Yes, ma'am.
Respondents have filed
Affidavit in reply.
So filed our affidavit in reply.
All the respondents?
Yes, yes.
Yes, we just
Respondent 1 to 5 minutes.
one
1 to 5 minutes.
respondent. 1 to 5. One to 5. Okay.
The lordship, if the case will, if the measurement fixed for hearing is next day.
It is submitted by the learned counsel for the parties that pleadings are completed
Lordship.
and the matter can be listed for hearing in the usual course, listed accordingly. Usual course. Okay.
Since the conducting counsel will be coming from Gauhati.
It's all right. Usual course. We will not give any special preference to any lawyer from outside. Okay, next.
Obliged.
For admission, item number 11.
Mr. Lordship.
Yes.
Lordship, I may allow to make some certain correction in my affidavit and opposition. Here in convention and appointment, here actually the petitioner is in serial number 73, but in my affidavit I put 72. Lordship.
72.
Lordship.
Who is your affidavit in reply?
Lordship, I'm bearing on behalf of my senior Cynthia, Lordship.
Okay.
She has some personal difficulties.
The learned counsel for the petitioner is allowed 2 weeks time to file affidavit in reply. Mr. M, you are M. Longkab,
No, Lordship, I don't get.
Mr. So-and-so, learned government advocate is allowed to make necessary correction with what?
Serial number 72 in serial number 72.
In the affidavit in opposition. In paragraph,
Bara 6, Lordship.
in paragraph 6. Where?
6, Bara 3. Last, Lordship.
Para 6.
Lordship. Last line.
Nothing is there, serial.
Lordship. Bara 6, last line.
I'm on para 6, your affidavit.
Lordship.
Para 6, there is no serial. No serial is mentioned. You want to correct 73
Lordship.
to 72,
No, 72.
72 to 73,
Lordship.
but nothing is mentioned here. Just see your para 6.
Lordship is here.
Does it start with that with regard to the statements made in paragraph 17, 18, and 19?
The next bara, Lordship.
Oh,
Now the petitioner is in the recorded at serial number 72. In the
which paragraph?
Page 3, Lordship, page 3.
I am on page 3.
Last
Now
one.
the petitioner's
Last
name is recorded as, okay, in the seniority. Kevi, what was that last sentence? 6. where the where the serial number of the petitioner is reflected as para 72 instead of para 70, serial number 72 instead of serial number 73 in the seniority list of applicants for appointment on commissioner grounds. Okay? Okay, listed accordingly. Okay.
Any other question? Okay.
For admission, item number 12.
Lordship, I'm appearing in item 12 and 13.
Yes,
Lordship, the respondents are not appearing in this matter. Lordship. The service is complete.
state. Who's for the state?
Lordship, on earlier occasion also none of them have appeared.
Please wait.
Yes, Lordship.
What about 1, 2, and 3? No state. Anyone appearing for 1, 2, and 3?
Lordship, no one has appeared.
Zat Kulnu. Respondent number 1. Whether there is any interim order?
Yes, Lordship.
Interim order. Interim order is
Yes.
there.
Yes, Your Lordship. Interim order is there.
Okay. Whether you have ascertained the proper and the correct address of the respondent number 4.
Respondent number 4 is served by notice in the newspapers. And that is a private party. And respondent 1, 2, and 3 are the officers of the GST department. They have been served here. All the service affidavits are on record.
Okay, we list the date for hearing. Even without the other side.
Lordship.
MS, your good name?
Aarti Agarwal, Lordship.
MS Aarti Agrawal, the learned counsel for the petitioner. None appears for the respondents. Despite service of notice. Listed for hearing. In the usual course. Okay.
Lordship, Lordship 13 is also same.
13.
13 is also same.
13. Same order in 13.
Serial number.
Okay. Same order in 13. Okay. For admission, item number 14. Yes, ma'am. Has not filed wakalat number. You are appearing for? So why is it taking so long for you to file your wakalat nama? You are filing for 4 and 5. And ma'am, you are for 5. Have you filed your wakalat nama? Have you filed your affidavit? Who is for the petitioner? Jatin Muli. Yes. Whether you file your affidavit? When can you file your power, madam? When can you file your power? Wakalat nama after 2 weeks. MS so-and-so, learned counsel for the respondent number 4 submits that she will be filing the wakalat nama in the course of the day. Stop. Both the learned counsel for the respondent number 4 and 5 are allowed 3 weeks time to file their respective affidavits. Okay. For admission, item numbers 15 and 16. Yes. Yes.
I think number 16, I'm for a petition.
Yeah.
If I receive the opposition in part of the state respondent, as well as respondent number 19 to 23.
19 to 23 in
And
WPC
WBC number
187.
239. And I need 16.
In item 16 239. In item WPC 187, state respondents have not filed their counter affidavit. Is it so? One in 187. In both?
Yes,
In both. Mr. Taka, you're for?
I have already filed.
Okay. You are in which?
19 to 23, 25, 2101.
Okay. So you have filed your affidavit.
Yes, filed. Now I'm for small number 24 in. Number 239. I can find my counter worship.
You-
In 1 week's time worship.
You're for?
Small number 24. In item number 16, before.
You will also file your affidavit in reply, or you have filed?
No, I have to file. Well, in mistake of the service report, in mistake of item number 16. In mistake of after our office book dated 2/12/2024 and 16/1/2025. Because the service report is yet being completed in mistake of some current response.
This is in item?
Item 16 years. The BBC 239. Which is password office note, service report in mistake of small number 5, 7, 9, 10, 11, 12, 13, 14, 15.
No, because here AD received in respect of, however, still away, okay. 5, 7, 9, 8, 9, 10, 17, 10 to 17, 19 to 44, 46 to 48,
So
50.
from 18, from school number 18 onwards, receive a service bonus conferences by learner senior training is preparing. Senior person is preparing for.
So which are the
Now the default are respondent number 5,
5,
7,
7,
9,
8? What about 8?
8 is coming.
9,
9, 10,
10 to 17?
yeah, 10 to 17.
10 to 17. That's all.
That's all. Worship, yeah, without worship, I mean, allowed to take steps by publication in the paper, in the newspaper.
What about this 187?
Worship, 187 by.
Lordship, notice is complete and the state government, they have filed the affidavit. Also.
Okay. In respect of all the respondents?
Yes, Lordship.
Okay. And you were making a, Mr. Moore, you were making a mention in which you are for respondent number 24, in which WPC 239. 239, okay. The rest of file, correct?
Yes, sir.
Okay. In this 5, 7, 9, 10, they are resident of?
Five is from Kohima.
No, from Nagaland or from other state?
From Nagaland.
From Nagaland.
All
Okay.
from Nagaland.
It will record one of the SRT
Asset.
of doctors in medical department.
Okay. This will be in 239, okay? WPC 239. Mr. Limawabang, the learned counsel for the petitioner, is allowed to take steps for service of notice upon respondent number 5, 7, 9, 10 to 17 by paper publication. Stop. The notice shall be published in at least 2 local newspapers, which is widely circulated in the place where the respondent resides. Stop. Mr. Tushi Olonkamer, learned counsel for the respondent number 24, is allowed. No. They not before Tushi Olonkamer. The learned counsel for the petitioner shall take steps for making the publication within 7 days from today. Showing the next returnable date as 22nd of? Then it has 22/4/2025. Then thereafter, Mr. Tushi Olonkamer, learned counsel for the respondent number 24, is also allowed to take steps. Is also allowed time to file the affidavit in opposition. Okay. So what about 187?
Yeah, this is Lordship. Lordship in 239, registry may kindly be directed to reflect the names of all the counsel for the respondents in the cost list.
Okay. The registry is directed to reflect the names of all the learned counsel for the parties in the daily cost list. Okay. What about 189?
Chief, our case will be decided by the outcome of item number 6 number 2 PC
239.
Yes, Lordship.
Okay, so list this even 187 listed on, we have given a date, no? 22/4/22.
Lordship, there's an interim.
Stop. The interim order passed earlier shall continue till the next returnable date. Okay. Interim in both the case, okay? The interim order passed in the writ petitions, in both the writ petitions shall continue till the next returnable date. Okay.
For admission, item number 17.
Please, Lordship.
Hmm.
Lordship, I'm yet to receive instruction to reply.
You-
Position. So kindly allow 3 weeks.
Notice issued upon respondent number 1 to 5 by the issuance number so and so. Return serve, you are representing which respondents?
1 to 5.
1 to 5, okay. Respondent number 2 who is awaited, 1 to 2, 4 and 5, okay. So you are representing all the respondents,
Yes,
1 to 5.
yes.
You have filed your affidavit?
Not yet. I'm appearing for the petitioner, Lordship.
Okay, so the respondent is.
Last occasion, Lordship, they took time for filing Wakalanama, Lordship. It's already reflected.
Have you filed your power?
Yes,
Have you filed your power?
this morning I learned.
This morning?
Okay, Lordship.
Heard, Mr. So-and-so, your good name?
This is Said Murtaza Ahmed, Lordship. It's already reflected in the course list, Lordship. It's Said Murtaza Ahmed, Lordship.
S. Murtaza Ahmed, okay, Kevin, course listed. Learned counsel for the petitioner and Mr.
And
M.
onion.
You please give a name. And Mr. So-and-so, learned counsel for the respondent number 1 to 5.
Yes.
Stop. The learned counsel for the respondent number 1 to 5 has submitted that he has filed the Wakalatnama,
Yes.
comma. However, the same is not on record. Registry to verify the same and placed on record. The stop. Respondent number 1 to 5 is also allowed 3 weeks time to file the affidavit in opposition listed on 17/4/2025. Okay.
Obliged, Lordship.
Yes.
From the supplementary cost list for admission, item numbers 27 and 28.
Supplementary course list. Yes.
Briefly, Lord.
Worship, I think in 728, the state has filed their affidavit. And they did not deny the amount which are payable to the petitioners. The only standard they have taken is the affidavit can be used. The first affidavit in WTC 225K of 2024. They have given a position filed by a respondent numbers 4 and 5. And the worship can come to paragraph 10.
Who is for respondent number 4 and 5?
Lordship.
You are for?
Your Lordship.
What about the other?
For all the respondents, Your Lordship.
Okay.
But here, Your Lordship, I'm here to receive instructions from respondent 1 to 3. I have filed on behalf of 4 and 5.
So 4 and 5, the worship is the BGV and the commandant. The commandant. And if you worship, you can come to paragraph 10 of the affidavit file. The affidavit says that with regard at page 3. With regard to the statements in paragraph 17 of the writ petition, the deponent respectfully states that the system of procuring ration via frequent tender was discontinued by such, and ration allowance per amount is introduced by the government. So this is subsequent to our contract. It is for this matter that the PSU submitted a consolidated proposal for clearing all liabilities with effect from people to which she did not inform. Details and such, but till date, PSU has not received the additional fund. That's all known.
Let us see from the government. Let the government file their affidavit. Because any sanction is to do with the government. So we have.
But it's not, the matters can be closed.
We gave them a short date. We give them a short date. So we give them a short date. Because anything to do with finance, I think this court also does not want to just jump it.
Your lordship, as an if it's.
Let the government also admit that there's so much amount is due to you. Then we can on the basis of that dispose immediately.
Everything is already admitted.
No.
It's just that what the GP is saying.
Let the government at least file the affidavit. At least. How much time?
3 weeks time, Your Lordship.
3 weeks too much. 2 weeks we give you. In the meantime, you file it. If it is admitted, admit. If it is disputed, just bring out the facts. What is disputed? Okay. And if it is admitted, then you have to pay. Okay.
Otherwise, let them verify and pay, that's all. This will keep matter pending, Your Lordship. Give them a time frame, verify and pay. If they find it, then we are.
We just give them one time, just 2 weeks.
Very good.
Next, maybe we will take that recourse.
Very good.
Okay. MS Mary, the Lena Senior Government Advocate, is allowed 2 weeks time to file affidavit on behalf of the respondent number 1, 2, and 3. Stop. It is made clear that if no affidavit is filed within the time allotted, this court shall consider disposing the petition on the basis of the affidavit in opposition filed by the respondent number 4 and 5.
Very well.
Okay, listed on. Seven four.
Very well.
Okay, madam, kindly 7/4/2025. Okay.
That's nice.
For orders, item number 18.
Excuse me, just 2 minutes.
For orders, item number 18.
Yes, ma'am.
Yes, Lordship. Lordship, on behalf of my agent, the state is certified, so tell that she is that.
Service report in respect of 5 to 7. Ma'am, 5 to 7.
Notice upon the project is from 5, 6, 7 are still alleged.
Correct. We are just watching. Okay. Awaiting service report on respondent number 5, 6, and 7, listed after 3 weeks. stopped. In the meantime, the government advocate is also allowed to file affidavit in opposition.
For orders, item number 19.
Mr. Lordship,
Yes, ma'am.
I have instruction to appear for respondent number 6.
Okay,
We have filed a ballot just yesterday.
okay.
So 4 weeks time will be given to me. by the
Respondent number 4,
Yes.
respondent 6, okay. Yes, yes. Yeah, for the petitioner.
Yes.
MS. So and so. Whether a status file. MS so and so. The learned counsel for the respondent number 6, as well as the learned government advocate, are both allowed 4 weeks' time to file their respective affidavit in opposition. Listen.
For hearing, item number 22 and 23.
I think hearing it may be difficult for this court to carry the files and move around. During this last stage of our service, it is good if we have been kept in one place so that at least there is no location, we can at least pass 1-2 judgment. But 1-2 weeks here, 1-2 weeks there. But what is your case? Pending bills. Madam, pay.
It's premature, Your Lordship, because completion certificate has not been issued. And moreover, it's a centrally sponsored scheme and it which has been dealing. So we are on it. Yes.
The second thing that is very common is that this project has been leading by from the central government. The central government has also filed the affidavit just recently stating that it is already in the policy of the board of the state government. And they have also submitted a specific statement that the petitioner should be released.
That-
amount pending at the earliest. That is also the observation made by the central government while filing the affidavit just recently.
Central government cannot show the liability on that in the state. Yeah, they have released only 20% of the submitted proposal.
You have completed the work.
Yes, boss.
Was
There's
it?
no completion certificate.
See, that may create some problem again,
Yes.
Mr. Moore, without completion certificate. The state government, whether they may have a right or not, but they will jump on that.
There's a verification report, which clearly states that report on whether it has completed or not, actually. Yes, clearly stated, in fact, Lordship, on that earlier occasion, 11 lakh rupees have been released also. That also shows that it is an admitted liability.
No, those small 11 lakh must be the running bill.
This also I agree, it's a running bill, and there is a pending bill amount which is 29 lakhs.
29 lakhs.
29 lakhs.
In the both the cases are
Yes, it's
So- different amount.
different.
Different amount.
Amount is also the same, just part 1 and part 3. Otherwise, the nature of the work is also the same.
See, this is here, whether you have met the Union of India.
Yes, Lordship.
Yes.
On the instruction of this on the board after taking up the hearing.
Ah.
On the earlier occasion. So
Yes, Mr. Younger Wati. I am just seeing your face, so I remembered CGSE. I think you were also one of the main parties in this case
Yes, I
because
saw my active.
you filed your affidavit.
Yes.
Okay. So what is your stand? Paragraph 3 of affidavit in opposition filed by respondent number 5, correct.
It's more better.
Yes, please.
That at the various offset, it is stated herein that in pursuance of the recommendations of the Foreign Finance Commission, the product infrastructure development of the destinations and circuits scheme was dislinked. From the unit support, and no budgetary provision was made since 2015 to 16 onwards. The state government
of Nagaland was informed by MOT DO letter dated so dated 13/2/2017 copy close that the BIDDC scheme has been deleted from the UN support and the scheme has to be implemented by the state government from their resource. It was also requested to the state government of Nagaland by the said letter that the utilization certificates in respect of the funds already released for such unfinished project may be provided to the MOT with the details of the physical progress and the unutilized fund, if any, may also be made available to the MOT. In case it is not possible to provide the corresponding utilization certificates. For the project has been delayed project. The project paraphile.
But I think ultimately, madam, state will have to explain this.
Yes,
Because in spite of the linking, why you have allowed the petitioner to continue?
Yes, that's the question.
And maybe on the issue as to whether the work is finished or not, I think maybe this court may have to constitute one committee to verify.
No,
I think that is,
that would be.
but I think let us take up on the next date.
Yes.
I think that will be the better way of working out.
I mean,
Because now the question of payment is there. When you don't want to pay, you will not give any works completion certificate. So now it is for the court to jump in. Okay. I had the learned counsel for the parties listed again on when?
After 2 weeks.
8/4/2025. Yes.
See,